Welcome everyone again. We are going to be talking about the Eco Oro and Colombia decision today. This event is organized jointly by the IEL Collective, the Essex Business and Human Rights Project, and Globe Center at Warwick University. Our panelists, our distinguished panelists, will comment on the Eco Oro Tribunal's findings and the broader context of the dispute, its implications for local communities, environmental and social policy, and on the investment treaty system. Just a very brief background to the case. Probably many people here are already aware of the case, although it was a very long award, so people may not have had the time to read everything, all of it. It took me a couple of days to read it. So the case concerns a dispute between Eco Oro, a Canadian registered mining company, and the Republic of Colombia, and the dispute arises under the Colombia and Canada Free Trade Agreement's investment chapter. And the dispute involves gold mining activities in the vicinity of páramo of Santurban in Colombia, which is a fragile wetland ecosystem that provides fresh drinking water to millions of Colombians. After the mining activities were suspended in the area of Eco Oro's concession, the mining company filed this dispute, this investment treaty claim under the treaty, seeking compensation for indirect expropriation and a violation of the minimum standard of treatment by Colombia. The majority of the tribunal held that Colombia's actions did not amount to indirect expropriation, and we're going to talk about that and the reasoning around that, but that Colombia did breach the minimum standard of treatment. The decision has already attracted lots of criticism, and there's been intense Twitter exchange on the decision, and I'm sure there will be a lot more written on it in the coming months. There was an environmental exception in the treaty, but that did not really influence the tribunal's finding of breach and did not prevent Colombia from being liable to compensation. We don't know yet the compensation amount. That's going to be decided separately. The case should not only be of interest and criticism because of the substantive findings, although those are obviously very serious, but it also raises interesting questions around the role of third-party funders and the innovative methods of getting third-party funders involved in investment treaty disputes. And there were also disputes between the parties around personal, material, and temporal jurisdiction of the tribunal itself. So there's a lot to unpack from this decision, and I will just now pass the floor to our panelists. We're going to start with Dr. Lorenzo Coutula. I'm going to just provide his bio quickly. Dr. Lorenzo Coutula is a principal researcher at the International Institute for Environment and Development, and he's a visiting professor at the School of Law, University of Strathclyde. At IIED, he leads research, policy engagement, and field-level projects on the legal arenas where natural resource governance meets the global economy. So Lorenzo, without further ado, I'll pass the floor to you. And you said you will discuss the broader context of the dispute and look at also certain findings of the tribunal. Lorenzo.
Yes, thank you so much, Anil. And I'm really delighted to be part of this conversation, particularly given the other panelists and the fact that so many experts are attending. Yes, I thought it might be helpful for me to take a step back for a moment and look at the bigger picture. And then I'd like to reflect on one particular aspect of the decision. So in terms of the bigger picture, the arbitration is part of a complex dispute that involves diverse actors, competing economic and environmental considerations, and also different views on how those considerations should be reconciled. So over the years, the dispute has affected relations between people who have long advocated to protect a unique, fragile ecosystem on the one hand, and people whose livelihoods fundamentally depend on mining, but also relations among multiple government agencies that have different institutional mandates on mining, environmental protection, and different branches of government, of course, the executive and the judiciary. There are two decisions of the Constitutional Court that were linked to the dispute. And of course, ultimately, the dispute has interrogated relations between the state and several mining companies, of which Eco Oro is one, and there are two other arbitrations that are currently ongoing. Interestingly, also, the dispute raises global dimensions as well, for example, as regards to climate, in that the páramo, the ecosystem in question, is considered an important carbon sink. So there are significant complexities in the nature of the dispute. And one first point I wanted to start with is just to reflect on the fact that in the face of this complexity, the very framing of investor-state arbitration places at center stage one particular set of interests, the interest of one investor. And the question really is whether those interests were unduly interfered with, right? Whether certain protection standards were breached, whether any exceptions would justify or excuse the breach, and ultimately whether that investor is owed compensation. In procedural terms, also, the framing excludes the diverse local actors who felt that their rights and interests were directly at stake. Prior to this decision, the tribunal took an earlier decision, a procedural order that rejected the application of certain environmental groups who were hoping to make an amicus curiae submission in the case. So fundamentally, there is a misalignment between the nature of the dispute on the one hand and the way the dispute is framed, understood, and ultimately addressed once it reaches this international dispute settlement forum. So coming to the dispute itself, I'm also yet to fully digest the dispute. It's a very long, the decision. It's a very long decision. It covers many important issues. I'm here really in collective brainstorming mode. And in my mind, there are certainly many questions that arise from reading the decision that would certainly warrant discussion. I have to pick one theme, and I'll focus on the tribunal's discussion of the minimum standard of treatment, partly because this formed the basis of the majority's finding that Colombia breached the trade agreement with Canada, but also because the theme, I think, offers insights on how the tribunal grappled with making sense of the complexities I alluded to before. So by way of reminder, the treaty makes it clear that the applicable standard here is the minimum standard of treatment under customary international law, MST, rather than an autonomous, fair, and equitable treatment standard, FET. We have a majority decision on the one hand and a partial dissent on this point from Philip Sands. And in many ways, that split is in continuity with earlier debates about the legal content of MST. Many of the arguments in the majority decision are familiar. We live today in a different world compared to the NEAR case, which first crystallized the MST over nearly 100 years ago, and customary law itself evolves, and we can look at arbitral decisions to make sense of those evolutions. And this type of reasoning, of course, takes us into FET familiar territory, such as legitimate expectations, regulatory stability and predictability, and so on. Though in this case, the majority also considered that MST requires some aggravating circumstances for a violation to occur. So that was really the majority decision and how they looked at MST. And this approach has been critiqued in other debates on the ground that it sets a low bar for establishing customary international law. It erodes the distinction between FET and MST. And here in this case, we have a direct critique of that approach in the partial dissent, which even includes a possible which even includes a hint at a possible ground for annulment. At some point, the partial dissent from Philip Sands asks the question of whether by effectively applying FET rather than MST, the tribunal may have manifestly exceeded its powers, which is an interesting point to note. But what really interests me now that I like to really focus on is how the tribunal applied the standard to the complexities of the case, and particularly the existence of multiple actors, interests, and considerations, and what this means really for making sense and assessing state conduct and whether state conduct breached the treaty standard. Now, the majority fairly long reasoning held that Colombia breached MST owing essentially to delays in the delimitation of the páramo, uncertainty and confusion, instances of inconsistent treatment of Eco Oro on the part of different government agencies, particularly those responsible for environment protection and those responsible for mining. And I think what is interesting is that in the partial dissent, on the other hand, there are interesting statements about more fully recognizing the different trade-offs that are involved in government action in general, and particularly when it comes to difficult environmental decision-making issues in the face, for example, of the transitions that need to occur to address or to confront climate change and biodiversity loss and so on. And that issue also involves considering the real life challenges the government face when they're grappling with difficult policy arenas. You have different actors and different considerations that are pulling government action in different directions. All different objectives are legitimate, but they might result in inconsistent signals coming from different government departments. So I think the partial dissent does critique the way in which, or aspects of the way in which Colombia handled the issues, but essentially it holds, relative to the majority, it holds that international liability requires particularly egregious violations, so a higher threshold that more fully recognizes these complexities. And also it ends up placing more emphasis on the due diligence of the investor itself and how that due diligence should enable the investor to identify and consider environmental imperatives and the ways in which those imperatives are likely to affect government action, regulatory frameworks, and the investment itself going forward. So it strikes me that this more plural view of government and this more plural view of public action is not only in sharp contrast with what the majority found, but also with the long line of arbitral jurisprudence that dates back to the TECMED tribunal, which, as many will recall, in a similarly complex dispute, held that government should be expected to act fully consistently and free of ambiguities and totally transparently, et cetera, et cetera. So a very different view, I think, of what government is and how it works, particularly when you have multiple actors, multiple interests, and really difficult, complex trade-offs that evolve over time. So to conclude, I think the case exposes the limits of the ISDS system as we have it, its lopsided framing, its procedural exclusions. The decision delivered what I think is a problematic outcome for multiple reasons, including the one I picked up on, that is the interpretation and application of the MST standard. But I think it's also interesting because the partial dissent offers new insights on what a more realistic, or what I think would be a more realistic approach to understanding government and government action could actually involve, including to better consider the complexities that are often at stake in these disputes. So I look forward to hearing from the other panelists and to the discussion together. Thank you.
Thank you, Lorenzo. Thank you for that really great overview and reflections on the decision, and especially on the minimum standard of treatment and the dissent's approach to what that means. So we're now going to hear from Dr. Ximena Sierra, and she will be speaking in Spanish. So you will, if those of you who are in the English channel will hear the translation of her intervention. Ximena is a Osgood Catalyst Fellow at York University. She holds a doctorate in law from Rosario University in Colombia, where she held the position as a lecturer in various disciplines of international law. Her research focuses on the colonial and post-colonial nature of mining policy in Colombia, and her thesis on the large-scale gold mining legal regime in Colombia from a post-colonial and from critical developmental perspective was awarded the highest distinction of laureate thesis. Ximena will talk to us about the broader context of the dispute, and she'll focus on the participation of local communities, regulatory chill, and environmental policy. Ximena, the floor is yours.
Bueno, muchas gracias, Anil, por la presentación. Bueno, muy buenos días, muy buenas tardes a todos. Muchas gracias al IEL Collective por la invitación. Estoy pues muy complacida de estar acá y discutir pues con los colegas y con los amigos presentes algunos de las posibles implicaciones y complejidades, como mencionó Lorenzo, del laudo de Eco Oro. Bueno, lo primero que quiero señalar es que la decisión tomada por los árbitros el pasado 9 de septiembre abre varios interrogantes, pero también confirma algunas de las hipótesis a propósito de las limitaciones que trae este sistema en los sistemas democráticos. En primer lugar, esta decisión indica que los tratados llamados de nueva generación y algunas de las instituciones incluidas en estos tratados de nueva generación, como el llamado derecho a regular, pues resultan supremamente insuficiente para tratar de reequilibrar las desigualdades propias de este sistema. Y lo segundo que queda claro es que algunos de los actores más afectados con este tipo de decisiones, como son las comunidades locales, permanecen invisibles y siguen siendo tratados como un tercero que no tiene nada que ver en este tipo de procesos. Entonces, en relación con la decisión del tribunal, quisiera destacar que esta es una decisión absolutamente ambigua, al punto que el pasado 10 de septiembre la Agencia Jurídica Nacional para la Defensa del Estado emitió un comunicado aplaudiendo y celebrando esta decisión, a pesar de que implica una responsabilidad y una posible condena e indemnización para el Estado. Es decir, como se dice coloquialmente, pareciera pues que este laudo es una especie de saludo a la bandera, y de hecho ese es el interrogante que queda en el aire con el voto disidente del árbitro Philip Sands, quien llama la atención sobre varios puntos. Yo quisiera resaltar tres que me parecen, digamos, supremamente llamativos. Lo primero que plantea es que el tribunal no respetó el texto acordado por Colombia y Canadá. Lo segundo es que la interpretación supremamente sui generis que hace el tribunal del artículo 805 y que prácticamente reescribe el artículo, muy probablemente va a conducir a socavar la protección del ambiente y por lo tanto a reactivar el congelamiento regulatorio o el llamado regulatory shield. Y en tercer lugar, lo que me pareció, digamos, más llamativo, que llama la atención este voto disidente, es que es muy difícil de comprender, casi que no tiene sentido, que los mismos argumentos que utilizó el tribunal para desestimar el estándar, la violación del estándar de expropiación indirecta, son los mismos argumentos que utiliza para declarar al Estado responsable por la violación del estándar de tratamiento mínimo nacional. Y pues esos son como algunos de los puntos pues que vamos a tratar de discutir y de entender. En este sentido, digamos, el árbitro fue claro en que el inversor conocía, o al menos en su deber de debida diligencia, debía conocer que para poder explotar debía conseguir una licencia ambiental. Y al momento de la inversión, el inversor sabía que el otorgamiento o la adjudicación de esa licencia ambiental era incierto. E igualmente sabía que el área concesionada estaba sobre un páramo, pues que era un ecosistema especialmente, digamos, protegido, y que el Estado colombiano estaba comprometido con la protección del ambiente, y que por lo tanto era muy posible que al menos dentro de los próximos 30 años, pues que era el tiempo de la concesión, se fuera a llevar a cabo, digamos, una reforma ambiental orientada, digamos, como a mejorar los estándares ambientales. En ese sentido, pues yo quiero destacar dos consecuencias que se repiten una y otra vez en este tipo de procesos, casi digamos como una especie de loop, ¿sí? O de círculo vicioso. Lo primero es que, como se advierte en el voto disidente, definitivamente esta decisión va a repercutir negativamente en la protección de los intereses públicos como el ambiente. Y lo segundo es que esta decisión demuestra que el atributo de la soberanía estatal, entendido bajo esta retórica vernacular del derecho internacional de las inversiones como el derecho a regular, opera como un artificio. Esto se demuestra, por ejemplo, cuando el tribunal argumenta que Colombia pues está en todo su derecho de proteger el ambiente, pero que al proteger el ambiente no puede afectar la concesión otorgada. Digamos, desde una lógica básica del derecho privado, esto podría llegar a constituir incluso una obligación imposible, pero, digamos, lo que me parece más problemático es que desde el punto de vista de la separación de poderes, esto sí puede redefinir reglas esenciales de la democracia. ¿Sí? Es decir, cuando el tribunal afirma que el Estado puede cumplir con la obligación de defender el ambiente, pero de manera coordinada y sin afectar la concesión, cabría preguntarse, por ejemplo, si eso implica que el Poder Judicial debe autorrestringirse en su potestad y en su facultad de controlar al Ejecutivo o si eso implicaría que todas las autoridades que operan en los diferentes campos, como el Ministerio del Ambiente, el Ministerio de Minas, siempre deben actuar de manera alineada y teniendo en el horizonte la supuesta superioridad de los intereses de los inversores. Y bueno, a partir de esto, quiero señalar como uno de los puntos que para mí están en el centro del debate, y es el papel y el lugar que ocupan las comunidades locales. ¿Sí? Es decir, en este proceso, en este caso, el gran ausente fueron las comunidades locales, ¿sí? Y esa ausencia, lo peor del asunto es que esa ausencia tiene mucho sentido bajo la lógica de este sistema, donde los inversores siguen siendo los actores centrales. Para ellos, estos procesos y lo que definen estos procesos, digamos, son una fuente de ingreso más, hacen parte de su capital supremamente sustancioso, supremamente jugosa, digamos, pero es un ingreso más, y es diferente a lo que representa para las comunidades locales. ¿Sí? Para las comunidades locales representa lo que definen estos procesos, representa una relación ontológica con el territorio, con los recursos de los cuales derivan su existencia. ¿Sí? Y para el Estado también representa algo más que un ingreso. Para el Estado representa un asunto, digamos, de una gran trascendencia en la esfera pública. Desde esa perspectiva es supremamente diciente que Eco Oro haya decidido llevar esta disputa hasta este punto o hasta esta instancia, sabiendo que no contaba, como nos explicó Lorenzo en este contexto general, que no contaba con la licencia social de las comunidades desde un inicio, conociendo, digamos, este proceso social multitudinario que se había llevado a cabo en Santurban por una serie de actores sociales, digamos, no solo comunidades, no sé, locales de la región, sino también, digamos, se había logrado como agrupar a empresarios que se veían afectados, digamos, como con esta decisión. Entonces, ese desinterés del inversor en escuchar a las comunidades y esa actitud de hacer oídos sordos frente a las voces de las personas que resultan más afectadas, es supremamente problemático, sobre todo teniendo en cuenta pues, que esta actitud también fue secundada por el tribunal, y como ya ha ocurrido, digamos, en otros procesos ante el ICSID, la narrativa del tribunal se sigue manteniendo principalmente entre dos partes, entre el Estado y el inversor. ¿Sí? Y de hecho, en este caso, el amicus curiae presentado por las comunidades en el año 2019 para poder intervenir y llevar sus preocupaciones, digamos, a este proceso, fue rechazado. Y el espacio participatorio de las comunidades locales se limitó a que en el año 2020, en la sede del Banco Mundial en Washington, pues se transmitía por televisión en una sala separada dentro de la misma sede del Banco Mundial, se transmitía, digamos, una audiencia. ¿Sí? Entonces, finalmente, quisiera señalar pues que este proceso no solo podría implicar, digamos, una grave afectación para el presupuesto de la nación, como ya lo sabemos, sino que podría alterar procesos esenciales democráticos, digamos, que garantizan los pesos y los contrapesos en una democracia. Y además, con este proceso, pues queda demostrado que soluciones que estaban pensadas para corregir, digamos, este tipo de desequilibrios que trae este sistema, son inefectivos, y no solo son inefectivos, sino que son parte del problema, ¿sí? Debido a que refuerzan que un instrumento de naturaleza de derecho privado pues tenga la potestad y tenga la capacidad de moldear las decisiones de los poderes públicos y de definir aspectos esenciales para las democracias y pues la vida misma de las personas, ¿sí? Entonces, eso es lo que tengo pues que señalar por ahora, y me gustaría también pues como ampliar de pronto algunas dudas que surjan en la parte de preguntas y respuestas, y bueno, me gustaría escuchar a mis otros colegas. Muchas gracias.
Thank you, Ximena, for that presentation. I'm really glad you referred to the resistance of local communities, because when one reads the award, all I can remember is how the tribunal presented locals as supportive of mining projects because of the employment it creates. There was not really any mention of local resistance. And obviously, when you have these kind of extractive projects, there's always supporters, there's always those who object to it. It's not like there's just a single view on these projects, but I think the presentation of the tribunal of the position of local communities was quite favorable to the investment, which is actually only presenting one side of the story. So we can maybe come back to that in the Q&A. So now we're going to hear from Dr. Jean Ho. Jean is an associate professor at the National University of Singapore. She lectures and supervises on diverse aspects of international investment law. The principal areas of her research are the law of state responsibility, the law of treaties, and investment contracts. She is the author of State Responsibility for Breaches of Investment Contracts from CUP, and she's a co-author of International Investment Law and Arbitration, again by CUP. Prior to academia, Dr. Ho specialized in investor-state disputes at Sherman and Sterling, and she's the first person to contribute in English, French, and Mandarin to the United Nations Audiovisual Library on International Law Lecture Series, and it's her birthday today, and she's joining us today instead of celebrating, I mean, I'm sure she's celebrated, but you know, she could be celebrating. She's joining us from Singapore where it's evening. So thank you, Jean. Jean is going to talk about the use of proportionality in Eco Oro and broader implications for investment law and treaty practice. Thank you, Jean.
Thank you very much, Anil, and to the birthday wishes in the chat. Thank you very much. It's my great pleasure to speak today on behalf of the collective. It's been quite a while since we got together for an event. And what better opportunity than this very chaotic, and forgive me if you are a fan of the award, because I'm not, this very chaotic Eco Oro and Colombia award. Well, it's chaotic because the tribunal is split on the two main issues, right? On whether there was indirect expropriation and whether there was a violation of the minimum standard of treatment. The first two speakers, Lorenzo, Ximena, have gone through the big overview, and that's awesome. So it's my turn. I'm the third speaker. I'm going to sweat the small stuff, you know. So it's a very specific point in the award and in arbitrator Gregarinoan's partial dissent. It's a chaotic award because it's an award that allows you to take whatever you want from it. And for that reason, I think it's very difficult for Eco Oro and Colombia to be a very authoritative precedent in investment arbitration. You have the majority award on indirect expropriation, which finds that, you know, the use of Colombia's police powers was legitimate. So it's good for those who, you know, want to more to be said on police powers, because that hasn't really been explored by a lot of tribunals. So you have people who would be a fan of that, or at least say that the award has given us something more. But you also have a partial dissent, which rules that the use of police powers was illegitimate. And then you have another split, which is on the minimum standard of treatment. And for those who want an interpretation of MST that's favorable, more favorable to the investor, you cite the majority award. You want an interpretation of MST that's less favorable to the investor, you will cite Philip Sands' partial dissent. So it's very chaotic because you can take whatever you want from it. And at the end of the day, I think an award that somehow according to one perspective is able to please everyone is an award that will please no one. So today I'm going to focus on a point which I think the tribunal, despite all these splits, they seem pretty united on, which is the adoption of the proportionality analysis to examine Colombia's conduct with respect to the indirect expropriation claim. So the proportionality analysis was adopted in relation to the 4 challenged measures. I'm not going to go through them in detail just because, you know, you can read the award for yourself. It's a frightfully long award, but we'll get through it. And of course, I must state at this point that, you know, I managed to read the award like twice. I haven't read it 17 times. So if I make a mistake and I misquote anything, please forgive me, right? So the proportionality analysis was applied with respect to the 4 challenged measures, you know, and you have to ask why. Why was the proportionality analysis adopted? Colombia argued against its adoption, but in my view, neither the majority, which comprised the chair, the president of the tribunal, as well as Philip Sands, I don't think they explained very well why proportionality analysis had to be adopted, nor was it well explained in the partial dissent. I will go through it to explain why I don't think the justification was quite there. Because the proportionality analysis in the first place is not found in the treaty text. And here I agree with Ximena that when you look at a lot of new generation investment treaties, they're supposed to be the hope for the future. They're supposed to rebalance investor rights and, the state's, freedom to regulate. And they don't quite hit the mark, so to speak, especially when you see them in operation in more recent awards. This is because a lot of the treaties are reactionary, meaning that the drafters tend to react to what has happened in the field, react to rulings, and they start adding provisions to circumvent the reoccurrence of certain rulings. So that's a reactionary approach to treaty making, and it ensures that you're always on the back foot. So, because you never can predict what a next tribunal will come up with. So they're trying to cut off the avenues which have been explored by existing tribunals, but you will have a new tribunal that will come along and do something which the treaty drafters did not anticipate. So the problem with a lot of the newer generation investment treaties is that they're reactionary. And this may be one of those examples. We're looking at Annex 811 or 8 Big 2 of the Canada-Colombia FTA. So we turn first to the reasoning of the majority of the tribunal. I could even say it's of the entire tribunal. I beg your pardon, because I got a bit confused with the splits. The majority on indirect expropriation, okay? I'm looking at paras 678 to 680, okay? Philip Sands, in his partial dissent, did not object to the use of the proportionality analysis. So I only can assume that he was in favor of using the proportionality analysis, right? The majority reasoned from good faith, and following from there, straight away they jumped into let's adopt the proportionality analysis. And analyze, right, if Colombia's measures were disproportionate vis-a-vis the result they wanted to achieve, which is the preservation, the protection of the páramos, all right? So whether the 4 challenge measures were disproportionate with respect to the end that Colombia had in mind. So that's extremely curious. I was not aware that simply citing good faith and saying that a state's conduct had to be, good faith conduct leads you inexorably, inevitably to a proportionality analysis. And there have been writings in the past, scholarship, exploring the incursion of the proportionality analysis into investor state awards. And proportionality analysis, according to these writings, which I'm inclined to agree with, is borrowed from the European Court of Human Rights. That's where it comes from, because a lot of the treaties, none of the treaties, sort of have a textual mandate for proportionality analysis. So you started off with a few tribunals adopting this sort of proportionality analysis, importing it from the case law of the European Court of Human Rights. And then it started to gain traction. But by and large, existing scholarship seems quite uncritical of this development. And I always wondered why. So I've not written on proportionality myself, but I'm not extremely convinced that this is a particular analytical framework that might work particularly well in investment arbitration without some kind of modification. Because when you think about it, the context of the rulings of the European Court of Human Rights is entirely different from investor-state arbitration. The European Court of Human Rights deals with human rights. That's the context. So your proportionality analysis is used to determine whether state measures affecting human rights are disproportionate with relation to the means that the state seeks to achieve. But in investor-state arbitration, you're dealing with investor rights. So to simply import proportionality analysis from the European Court of Human Rights context is equivalent to elevating investor rights to the level of human rights. And I don't find that something which should just be, well, swept under the carpet, or like, well, oh yeah, we should just accept it. I'm not sure if the equivalence proves itself. So the majority doesn't spend very much time discussing why they are adopting proportionality analysis. It seems to be taken for granted nowadays that the proportionality analysis is a good thing. It's a good analytical framework, and tribunals don't have to explain themselves. Sometimes counsel are the ones who propose a proportionality analysis, and then the tribunal simply adopts it. But I would imagine, given Colombia's objection as recorded in the award, that they don't want the proportionality analysis applied, this is an argument that comes from the investor. Then we turn to Gregarenowen's partial dissent, and I'm looking in particular at paras 16 and 31.5. where he writes, that when you look at Annex 811, subsection 2, subsection B, right, it requires an analysis of 1, pacta sunt servanda, number 2, good faith, number 3, proportionality, number 4, legitimate expectations, and number 5, abuse of rights. And if you turn to the provision that the partially dissenting arbitrator was looking at, he's the one who found that the exercise of Colombia's police power is not legitimate, all right? This provision reads, right, except in rare circumstances, such as where a measure or series of measures is so severe that in light of its purpose, it cannot be reasonably viewed as having been adopted in good faith, non-discriminatory measures by a party that are designed and applied to protect legitimate public welfare objectives, for example, health, safety, and the protection of the environment, do not constitute indirect expropriation. So one could argue that, well, based on the wording of this particular provision, we're looking at, well, a series of measures so severe in light of its purpose that it cannot be reasonably viewed. One could argue that, well, that kind of wording allows me to import proportionality analysis, because I got to tell you, in order to determine whether or not a measure is sufficiently severe, I have to adopt a proportionality analysis. Well, perhaps yes and no. The language that Gregarenowen uses in his partial dissent is one of balancing and weighing. And I think when you look very closely at the text, if we have no choice but to rely on the text of your newer generation treaties, we're not just talking about disproportionate measures. The measures have to be severely, inordinately disproportionate. So you have to we're looking at extreme disproportionality here. This is something that goes beyond the sort of regular weighing and balancing that the majority, comprising the president and Philip Sands, and the partial dissenter, Gregarenowen, was talking about. And that is why you have a split, because if you're just talking about a regular weighing and balancing, such that so long as the proportionality balance is tilted a little bit towards disproportionality, then a case is made out or a case is not made out. So that's why you have the majority falling on the side of the measures being proportionate, and you have a dissenter falling on the side of the measures being disproportionate. So herein lies the danger of the proportionality analysis. If one were loyal to the language of the treaty, then you would understand that it's not just a simple balancing exercise. It's not enough to just tilt the balance. The measures have to be severely disproportionate, all right? And only then will the exercise of police powers be considered illegitimate, or at least an indirect expropriation is made out. And I think that nuance may be lost on a lot of arbitrators who adopt the proportionality analysis. Because when you adopt that, the first thing that comes to your mind is, so long I find that the measure is disproportionate, the measure is validly challenged. So you're looking at 49.51%, but this is not the case here. And like I said, I think I think that nuance is lost. So in my view, well, in the first place, I'm not in favor of adopting the proportionality analysis. There are other ways to analyze if a measure is in violation of a treaty. And I don't think a proportionality analysis should be adopted unless there's express treaty language to that effect. But in any event, I think greater circumspection should be used when tribunals resort to proportionality reasoning. I have a suspicion that tribunals like to use proportionality reasoning because it allows them to demonstrate that they have considered all the pros and cons. So it makes the award appear very complete. But this sort of weighing and balancing in a way that I think is not, I think detracts, you know, from the wording of the treaty. I think is actually should be discouraged. So I am very happy to hear questions or criticisms on what I've just said. Like I said, I've only managed to read the award twice, you know, so apologies if I've missed anything out. But here we go. I'm not the biggest proportionality fan, but I stand corrected. Thank you.
Thank you, Jean. Thank you. Having read the award just once, I didn't pay very much attention to the proportionality analysis. And thank you so much for highlighting that aspect of the award, because, you know, my thinking has now really shifted. You were very convincing. I was never a fan of proportionality, and we have Daria here who's written an article actually debunking the use of proportionality in investment treaty arbitration, but thanks for that intervention. So if David's here, we're going to now hear from David Schneiderman. He's a professor of law and political science at the University of Toronto, where he teaches courses on Canadian and US constitutional law and international investment law. He's the author of over 80 articles and book chapters, and in addition, the author or editor of over a dozen books, including Constitutionalizing Economic Globalization, Investment Rules and Democracy's Promise, Resisting Economic Globalization, Critical Theory and International Investment Law, and his forthcoming book, Investment Law's Alibis, Colonialism, Imperialism, Debt and Development. I'm sure many of us here have cited his works, have read his works. David's going to talk about the curious distinction that the tribunal has made between the concept of reasonable investment-backed expectations under the expropriation clause and the legitimate expectations under the minimum standard of treatment. David, the floor is yours.
Thank you, Anil, and thank you to the collective, a group who I admire greatly and I think are going to transform the teaching and research in international economic law. And also want to say how honored I am to share this stage with colleagues who I admire as well, and many friends in the audience I want to say hi to. Okay, so Anil's given you a window into what I want to talk about, which is to describe a doctrinal puzzle. So I'm going to talk more about sort of the internal doctrinal moves rather than do socio-legal analysis, which I'm usually more inclined to do. And the puzzle arises in paragraph 804 of the majority opinion, where the tribunal says there's to be some difference. The tribunal's analyzing, and this is in the context of its discussion of minimum standard of treatment and fair and equitable treatment. In that context, they're talking about legitimate expectations, which is different from the earlier discussion in their reasons concerning distinct reasonable investment-backed expectations, which arises in the annex that Jean was just talking about, the expropriation annex, circumstances when an indirect expropriation arises will occur if, among numerous factors, distinct reasonable investment-backed expectations are upset. Now, legitimate expectations, distinct investment-backed expectations, one would think these are synonymous. And one would trace the origins of the entry of these ideas into investment arbitration. One doesn't find much of a distinction between its origins in US constitutional law. Distinct investment-backed expectations is drawn directly from US Supreme Court jurisprudence in 1977, which borrowed without attribution from a phrase authored by Frank Michelman in a famous 1971 Harvard Law Review article. And so the fact that investor expectations are upset are one of three factors identified by the US Supreme Court, and then get taken up in US model treaty language. The Canadian government immediately adopts that in its own investment treaty text, even though there's no constitutional property right in Canada. And of course, we've seen this kind of formulation of three factors, this multi-factor analysis, spread far and wide. So it's strange. And of course, we know that legitimate expectations is a product of arbitral invention, what Professor Sornaraja calls the sort of latitudinary and expansive interpretation of minimum standard of treatment and fair and equitable treatment. So it's entered into that discourse via arbitral interpretation rather than text. So it's odd, and this is what dissenting arbitrator Sands says. It's particularly odd that there's no upsetting of legitimate expectations under the expropriation provision, but there is under the MST-FET clause. So I want to try and work my way through that. And I think I understand what's going on, although it's not well explained, which proves again that arbitrators are overpaid and less than average pretend judges. Okay, so under the expropriation standard, there's no express finding that there's upsetting of legitimate expectations. The tribunal says there's no specific representations that they can identify that the investor can rely upon to satisfy the multi-factor analysis in the expropriation analysis, recalling that it's one of three factors. It seems to me that the tribunal's convinced, rightly so, that this was a legitimate public welfare objective that was being pursued, and that arises in the formulation that Jean was talking about. So this was a legitimate environmental regulation protecting the páramo and freezing mining in that area. So the balance weighs in favor of Colombia, an exercise of police powers, a sonorous way of talking about this, in the pursuit of a legitimate public welfare objective. In the MST-FET discussion, legitimate expectations is isolated, right? Pulled from the expropriation discussion, one would think in theory, and then isolated as a ground in and of itself to find for the investor. Curiously, though, there are no specific representations made to the investor, the tribunal finds, but there are inducements and other representations. There's delay, there's inconsistency, uncertainty and confusion. These are all the synonyms that the tribunal identifies that cumulatively frustrates the legitimate expectations of the investor. So it seems to me that this is part of the phenomenon we're seeing where FET, MST is overtaking expropriation, isolating one factor in the expropriation analysis, pulling it out, emphasizing its significance under another ground, not crowded in by other considerations, right? Like the multi-factor analysis identified in the annex, in addition to other factors that we find in disputes like Pope and Talbot, control, profits, and so forth, are factors that typically will weigh into an expropriation analysis. All that stuff is emptied out in MST-FET. So this case then is a very good example of how, and there are others, of course, how legitimate expectations is overtaking the expectations factor in expropriation, and how expropriations are less likely to be found by arbitrators. It's less insulting to a state, right, to say that it violated FET than expropriation, which allows the Colombian government to issue a press release saying, see, we weren't guilty of an expropriation. But that's not the only thing to worry about here. By isolating legitimate expectations in this way, the context drops out of the picture. There's no discussion of the legitimate public welfare objective that was being pursued by the Colombian authorities to protect the páramo, right? That arises in the context of the expropriation analysis, but not in the context of MST FET. And moreover, the due diligence discussion that arises in the course of the expropriation analysis, the tribunal finding that any due diligent investor would have known that the Colombian government was under an obligation, a duty to protect the páramo, would have known or expected that the mining regime would be unsettled and would be disrupted, doesn't appear anywhere in the MST FET discussion, which makes this MST FET discussion look like the discredited, something like the sole effects doctrine, this discredited sole effects doctrine under expropriation, where you just look at the impact on the investor and nothing else. So it looks like that discredited doctrine has migrated in some ways to MST FET. And the last thing I want to say, and this harkens back actually to a point that Lorenzo was making, and that is that Philippe Sand's dissent highlights this feature that these kinds of questions are complex ones. There are multiple actors and different arms of the state, and Philippe Sand says this, might be pursuing contradictory policies that state theorists have long been beating the drum around this. And I'm referring to theorists like Bob Jessup, who is drawing upon the work of Nikos Balantzis, that states are not homogeneous unified wholes, rather they're shot through with contradictions. And the right hand of the state, the one promoting investment, might actually be behaving in ways that is inconsistent and in tension with the left hand of the state that might be pursuing social policy, environmental policy goals, etc. Outside of an authoritarian regime, states typically are not going to be unified wholes in the way that, as Lorenzo reminds us, the states described in TechMed. And so Sand says this at paragraph 28 in his dissent: different arms of some government may inevitably give expression to different conflicting priorities. The fact that this is acknowledged in even only in a dissent, I think is significant, because it brings an element of realism and lines up nicely with what theorists of the modern state have been saying for some time. My fear is that this point will be lost in future arbitration. So in conclusion, let me say, drawing on idea that Jean is talking about proportionality, it might be useful to bring proportionality into play in assessing and evaluating how disproportionate this regime is in protecting investors over other important societal objectives. Thank you.
Thank you, David. Thank you so much. When I was reading the award, I felt like two different sets of people wrote those two reasonings on the legitimate investment backs expectations and the legitimate expectations under the MST analysis, because they were relying on the same facts, the same kind of concepts to come to different conclusions. It was unbelievable. And it's almost as if the investor is kind of rewarded for waiting that the state will, over the 20 years that it was waiting for this license, this environmental approval, that the government would opt for the harmful policies for the environment. When we talk about due diligence on the side of the investor, we expect that to happen from the start of the investment and at every stage. And here what we see is it's almost as if the investor was just waiting there so that the government would finally give up and decide that you can explore gold in the páramo. So finally, we're going to hear from Professor Sornaraja, who I'm sure everybody knows who he is, but I will read his bio. He's an emeritus professor at the Faculty of Law of the National University of Singapore, and he's a visiting professor at the London School of Economics. He's a leading international investment law scholar and the leading voice of resistance in this area, I think. And he's the author of many books that anyone working in international investment law has, I'm sure, read and cited: The Pursuit of Nationalized Property, International Commercial Arbitration, The Law of International Joint Ventures, The International Law on Foreign Investment, textbook for anyone teaching investment law, and more recently, Resistance and Change in International Law on Foreign Investment. So, Professor Sornaraja, the floor is yours.
Thank you very much, Anil. I think the fate of the last speaker in any of these panels is that all the points that he wanted to make have already been expressed. So I have to think of something that's rather new to say, and I'm sure that I'm going to eventually be repeating many of the points that such an excellent panel would already have made. Because as Anil pointed out, this award is very long. And one reason why it is long is that it contains restatements, chunks reproduced from the judgments of the Constitutional Court. And when you read the chunks reproduced from the decisions of the constitutional courts and the judicial bodies of Colombia, one can understand that there is enormous amount of juridical thought that has gone into the shaping of those awards. And sometimes I could not help thinking that the Constitutional Court and its judgments were far superior to the award that was really made. So there has been a thorough analysis already made by the Constitutional Court, the balancing of the different interests if they are relevant. All that has been done by the Constitutional Courts. In the old days, the idea was that you did need investment arbitration because the courts of the developing countries did not know the law or were corrupt. And that is not anymore the case when you look at the awards of the Colombian courts, because they are thorough, exhaustive, and as David said, the officials of the Colombian state have analyzed different interests. Like, for example, the Attorney General clearly thought that there were other interests to be considered besides the environmental interests. So there is a thorough analysis that is contained in the judgments of the Colombian court. So I come back to this idea of balancing, which seems to be present throughout the award. Balancing treaties, the significance of this award would probably lie in the fact that it is one of the early awards which considers a balancing treaty. So we have already been told that the existence of balancing treaties is a great reform that has been made to the law because of the fact that now you have the treaties recognizing the fact that there should be attention given to environmental considerations, to human rights, to labor rights, to corporate social responsibility perhaps. But we see that there is a reaction amongst arbitrators to this possibility, and that reaction is evinced in this award. You find, of course, the idea that as far as expropriation is concerned, the door has to a large extent been closed because of the fact that you have the right to regulation being clearly expressed in a provision which talks about indirect expropriations being compensable, being not compensable except in rare circumstances. To counteract that, perhaps the arbitrators discovered this proportionality theory. They wanted to reserve in themselves the right to look at whether regulatory expropriation was truly proportional. And we know, as explained by Jean and David, that this is a law that has been taken from other sources, like the German court, which perhaps is the best originator of this notion of proportionality. And there's the Israeli courts, which deal with it in the terrorist cases, and of course, the European Court of Human Rights. But nevertheless, it is an importation from another discipline into investment law, and it is something that sits uneasily with the notion of investment law. That apart, we see the enormous focus that is diverted into the notion of fair and equitable treatment. So the door of expropriation closes because of the notion of indirect expropriations and regulatory expropriations. There is this effort that is made to ensure that in respect of the so-called balancing treaties, there would be an expansion of the possibility of liability being found on the basis of notions like legitimate expectations. As David pointed out, legitimate expectations itself is an import from the domestic law of different countries, perhaps of the common law particularly, where it is used only as a proposition of procedure, providing natural justice in situations where legitimate expectations have been violated. But here we find that there is a appearance of that rule as a substantive proposition. You violate legitimate expectations, there must be damages that must be paid. So that idea, which is resisted both by Canada and by the United States, because you do find in the submissions that Canada and the United States have made in recent cases that they do not think of legitimate expectations as being a part of the law, customary law relating to minimum standards. So despite that, we find there is an assertion of the doctrine in the awards. It's also interesting in the award to see how Canada has been treated. The Canadian intervention is cited quite often, but it would appear that it is given short shrift in the award because the Canadian interpretation of matters isn't reflected in it at all. The other difficult idea is the use of customary international law. Now, one would think that customary international law is made by states, but not to this particular tribunal. In this particular tribunal thinks that customary international law is made by consistent repetition of the same principle in a series of awards. So what we find in this award is a continuous repetition of previous awards in order to find customary international law. It's also interesting to see that every so-called balancing treaty contains an annex in which customary international law is defined as the law that is made by states, by continuous practice of states, as all international lawyers know, is made by continuous practice of states with opinio juris. But that's not how the tribunals have treated it. So eventually one has to come to the conclusion, unfortunate conclusion, that tribunals are going to embark on a new course of activity when it comes to balancing treaties. Because we know that balancing treaties are intended to ensure that there is a favorable element of exceptions created. And that in itself, it's a bit awkward really, because why would a state want to create matters of public interest as an exception? One would think, as David probably has pointed out, that states exist because they protect the public interest. I mean, you're told when you start the constitutional law course, that the interest of the public is the supreme consideration of the state. It's manifested, I believe, in a Latin maxim, salus populi suprema lex. But what we find in these awards is an alteration of it to read salus investoris suprema lex. You know, that the supreme consideration must be the interest of the investor. And that's the tenor of this award. You know, I mean, you sort of discard expropriation, but you have to struggle to find a way of ensuring that the investor remains protected, despite the fact that there are these exceptions. The fault lies, I think, largely with the states in making these balancing treaties, because the primary task of the state should be to protect the public interest. And in this case, the interest was the protection of the environment. In the case of Colombia, that interest is not only a Colombian interest, but as one would think, it's a global interest, because there is such an interest in climate change. There is a reference in the award itself to the many international treaties that had been made, to which Colombia had subscribed to. So in that context, then, Colombia owed not only an obligation to investors, which are only bilateral obligations, but a multilateral obligation to the whole of the international community to ensure that this area remained protected and is not adversely affected by the workings of the foreign miners. So in that sense, also this award comes as a great disappointment. And finally, of course, one would obviously look at this award and note that it's pretty predictable. What the outcome of this award is quite predictable, in the sense that one knows that Sands is an environmental lawyer, has written a major text on environmental law, and I don't want to talk about the other two arbitrators, but you know, if you look at the consistent record of these arbitrators, you know that a commercial arbitrator is going to decide a case purely on the basis of considerations that are favorable to the investor. So this idea that, you know, it's the words of the treaties that matter, I don't think that counts. Words don't count at all. It's what is infused into the treaty by the arbitrator which counts. And that is the sad thing about this award, because it infuses into the so-called balanced treaties a new way of expanding the scope of the avenues provided for the finding of responsibility of the state, despite the fact that the state, like Colombia in this case, had good reasons to do what it did. So let me end there. Thank you so very much. Thank you.
Thank you, Professor Sornaraja, for your reflections. We are going to open the floor up for questions, but I was just thinking your intervention made me think about a passage from the award where the tribunal refers to the preamble of the treaty and refers to how both environmental protection and protection of the investor and promotion are referred to in the preamble as among the objectives of the treaty, and therefore they're equally important, and one doesn't supersede the other. And that was part of the reasoning of the award when they were analyzing the minimum standard of treatment, that one doesn't supersede the other. Interestingly, this was done in reference to the preamble rather than looking at the exception clauses and what that's telling us. Right. Okay, so it's time for the Q&A, I think.